I should start this lecture by thanking, but first of all, I hope you can all hear me. So, thanking the Curatorium for having done me the honor of inviting me to deliver this inaugural lecture, and especially in the context of these winter courses, because when I was Secretary General, everything happened in the summer. And I must say, I'm very impressed to see how big the audience actually is for these winter courses. So I thank the Curatorium. I would also like to thank Jean-Marc Touvenin, and I certainly have no regrets in having appointed him because I can see that he has very much proven to be worthy of this trust. And with no further ado, I would like to address my actual topic, which is that of international rules of jurisdiction having regard to contemporary state practice, stability, or change. For international law experts, the current world situation is difficult to grasp. There's so much upheaval, and sometimes chaos seems to prevail, both at international level and indeed at domestic level. And faced with such situations, the international law experts are sometimes confounded. And yet, traditionally, it is international law that has been entrusted with establishing a certain order between sovereign states, curbing violence, and promoting links between different domestic legal orders. As you are no doubt aware, the question of extraterritoriality has been troubling many recently, particularly in connection with unilateral sanctions that seem to be gaining ground quite considerably, though that is not actually the subject matter of the present lecture. What I will seek to do, however, is to return to the fundamental principles that underpin state jurisdiction under international law, and then in the light of these fundamental principles, it will then be up to you as lawyers to address and, more importantly, to apply your critical faculties in assessing the measures that seem to be providing the current backdrop to international relations at the moment. Therefore, let's return to the beginning, the need for principles and rules designed to govern state jurisdiction. This is a need that only arose progressively in international life and quite late in the day, in fact, as a corollary to the development of concepts pertaining to state sovereignty. Sovereignty established itself in Europe towards the end of the 16th century and was seen as the hallmark of the supreme power of each monarch and then of each state. And from this original understanding of sovereignty, conceived as a supreme and unconditional power, ancient scholars such as Grotius or Vattel derived powers and rights for states, broadly inspired by private law, but without any clear limitation. In fact, the only obligations were those that states had actually consented to. So such is the formulation to be found in the writings of scholars who focused on the law of nations, and later on, when we started talking about international law as a concept in the 19th century. And in this classic conception of international law, whose practice its authors sought to make systematic, the focus was on the practice of chancelleries, particularly as concerns diplomatic relations or the situation of armies on foreign soil, and also, of course, treaties. This classic conception of international law is very much marked by an absolute conception of sovereignty, justifying unlimited freedom of scope in state action, particularly when it comes to the use of force, although it should be pointed out that this system sought to guarantee a degree of legal certainty and stability for treaties. So this understanding of sovereignty has, needless to say, evolved a great deal, and sovereignty today appears as the guarantee that states may exercise their sovereign rights as recognized under international law. And of course, the constant negation of any legal subordination to a world that is external to that state. The very term jurisdiction, compétence in French, applied to states under international law, made its first appearance in an article that was published in 1906. However, it was only until the mid 1920s, about a century ago, that we see this concept of state jurisdiction being systematically and judicially used. And one witnessed the emergence of the basis of a genuine theory of jurisdiction in French and Belgian legal thinking that was later developed and applied more systematically in two courses delivered here at the Hague Academy of International Law, presented by Frederick Alexander Mann. The first one was in 1964 and was entitled The Doctrine of Jurisdiction in International Law. And then that was followed 20 years later on by the Doctrine of International Jurisdiction, revisited after 20 years in 1984. A little bit like in the novels of Alexander Dumas. So, how should one define jurisdiction? Well, generally speaking, this concept refers to legal powers that are recognized by international law or bestowed upon a subject of law, which might be an institution or a body. And this empowers them to rule on a case, to fulfill a specific function, or take a decision, or indeed accomplish an act. And if you're looking more specifically at states, the notion of jurisdiction, in fact, has a dual function. On the one hand, it provides legal justification for the powers exercised and the act accomplished by the state under international law, and the fact that they are enforceable vis-à-vis third parties. And on the other hand, this also governs the distribution of power between states, the power to act, as it were. From this point of view, the role played by the concept of jurisdiction is essential in guaranteeing the proper workings of and compliance with sovereignties in the plural, because sovereignties' coexistence is a hallmark of the international community. And it's also essential in coordinating the legal orders of different states. And this, of course, is a primary concern for specialists in private international law. And I would like to recall the lectures given at the Academy by Professors Paolo Picconi and Pierre Meyer, who addressed private international law from this perspective. Therefore, the doctrine of jurisdiction is a factor that provides organization and clarity in these legal powers, and also visibility for private persons. The international rules that govern state jurisdiction are of relevance to both public and private international law, even if the two disciplines do not approach these rules from the same angle. Indeed, the conflict of law rule is a domestic law rule, which makes it possible to designate the applicable law to a particular relation if there are several laws that are in conflict with one another. However, this conflict of law rule has now also been given a different backdrop, which is the limitations that may arise under public international law. Although private international law scholars will generally concede that the jurisdictions to which they refer are derived from public international law, it should nonetheless be noted that the tenets of private international law doctrine on jurisdiction, as illustrated by Professor Frederick Mann, were in fact set out as early as 1894 by Justice Story of the U.S. Supreme Court, and that was well before they became common currency, almost a century later in public international law. And at that embryonic stage, the premise, in fact, was a specific reference to a territory, being a justification of laws, but territory also being a limitation of the scope of laws. So the outlines of this doctrine of jurisdiction, which were laid out approximately a century ago, progressively adapted to keep up with considerable developments in international law, as well as the changing political, economic, and ideological context of international life. The principles that govern state jurisdiction play, of course, a fundamental role in terms of order, the prevention of tensions and disputes, as well as providing predictability of conduct. These last few years, you'll have seen practices of some states which seem to have departed from these principles of jurisdiction. But of course, concurrently, we've seen technological developments and the emergence of new phenomena which call for new approaches. And therefore, we shall look at how this doctrine of jurisdiction was asserted, what it consists of, and how it has been adapted, and what the challenges are today. So, the doctrine of jurisdiction was established in public international law in the 1920s, more or less, about a century ago, and really constituted progress in terms of allowing for the coexistence of different sovereignties. The introduction of this doctrine of jurisdiction had a major bearing on international law by circumscribing this idea of unlimited sovereignty and by restricting states' powers of legal action to what is allowed under international law. And as the Permanent Court of International Justice stated in the famous Lotus ruling, in these circumstances, all that can be required of a state is that it should not overstep the limits which international law places upon its jurisdiction. As you can see, jurisdiction is already mentioned in the quotation. Within these limits, the court continues, its title to exercise jurisdiction rests in its sovereignty. In other words, the sovereignty of the state justifies action up to a point, but beyond that point, you have to refer to international law. Now, of course, the rules of international law evolve, and these rules may restrict to a greater or lesser extent the rights of states. There are instances where these rules have not yet been agreed, which makes it rather difficult to state categorically what is authorized and what is not. Furthermore, a state may raise a legal claim unilaterally, which of course is insufficient to substantiate the existence of an international law rule, should an objection be raised by a third party state. So the doctrine of jurisdiction has a very solid core, but whose contours and application are marked by a certain flexibility and adaptability. This dual consistency lends this doctrine of jurisdiction a certain amount of robustness, but we still have the robustness with us today. But it is also adaptable. The way in which the doctrine of jurisdiction is presented will vary from one legal tradition to another. In the English-speaking or Anglo-Saxon doctrine, it is very pragmatic and descriptive, whereas in the French-speaking doctrine, particularly in France itself, it is more theoretical, more rational in its construction. And as a result, there are nuances in the way in which the different types of jurisdiction are presented, but ultimately the solutions are the same. The Permanent Court of International Justice and the International Court of Justice seem to have opted for the French doctrine approach by referring to titres de compétence, titles of jurisdiction, which we will look at in greater detail. These titles of jurisdiction correspond to an analysis of what a state is. Under international law, a state is an entity which is characterized by a territory, a population, and by a governmental organization and an administration that has certain powers. These are, in fact, the elements that will serve to inform or serve as a basis for the different titles that may be invoked by the states. As regards the nature of the jurisdiction exercised, I'd say there is an agreement between the English-speaking presentation of jurisdiction and the French-speaking one. We're talking about legislative competences, the jurisdiction to prescribe, the jurisdiction to enforce, in French, compétence d'exécution, and jurisdiction to adjudicate, in French, compétence juridictionnelle. And no doubt the most important title that can serve to support state jurisdiction is the territorial title, which is derived directly from the land base of any state, a base that is usually determined in compliance with the rules of international law. The territorial title is particularly robust, and it plays a positive role. It provides justification for the state to exercise all forms of jurisdiction: the jurisdiction to prescribe, the jurisdiction to enforce, the jurisdiction to adjudicate. But at the same time, it can play the part of excluding when it comes to the jurisdiction to enforce, according to the principle according to which a state enjoys exclusive coercive powers within its territory. This is a classic principle of international law, which was upheld by the Permanent Court of International Justice in its Lotus ruling, but which is also reflected in the prohibition on the use of force set out at the UN Charter. When it comes to areas that are not subject to sovereignty, notably the high seas, states enjoy a very broad margin of maneuver, and this is governed by international law and is exercised in principle by virtue of the flag state principle. Then, of course, you have a second title, personal jurisdiction, or ratione personae, which derives from the bond that exists between the state and its population. Its boundaries are defined by the states thanks to the powers it enjoys to grant nationality to natural persons and legal persons. But when it comes to legal persons, international law provides some indications which have been mentioned in by the International Court of Justice in the Barcelona traction case. Two formal criteria can be relied upon, namely the place of the headquarters or the place of incorporation of the company. And as a consequence of this definition of nationality of corporations, a subsidiary under local legislation of a company will not be deemed to have the nationality of the parent company. It will, in fact, have the nationality of the state where it has its headquarters or where it has signed its act of incorporation. Now, as you may be aware, the United States of America, in some legislative acts, such as the FATCA, the Foreign Account Compliance Act of 2010, requires that foreign financial institutions have to identify and declare their U.S. clients for tax purposes. This law and other American laws have adapted the concept of a U.S. person, which is based on a particularly broad criterion applicable to both natural and legal persons. And this may seem to fly in the face of international law. And there is, therefore, a source of potential conflict here between the USA on the one hand and their partners abroad. The economic weight of the United States of America, of course, gives them a fairly undisputed advantage in that respect. So, personal jurisdiction will grant states the jurisdiction to prescribe and the jurisdiction to adjudicate for nationals, even when these nationals are outside of their territory. But of course, for reasons which I have already mentioned, exercising coercive jurisdiction is not permissible. The title of personal jurisdiction, which exists under international law, can, of course, come into conflict with the jurisdiction exercised by the territorial state. Hence, this is why a conflict of law or a conflict of jurisdiction may arise. On that point, public international law tends to remain silent because these are matters that fall squarely within the purview of private international law, and it's according to the conflict of law rules that the situation will be resolved. The third title of jurisdiction pertains to the need for states to ensure the proper functioning of their governmental and administrative organization, as well as the proper workings of their public services, and to do this in particular where these might have been deployed outside the national territory. Obviously, if it's within the territory, then the matter goes without saying. So when it comes to government services, governments sometimes exercise jurisdiction outside of the country. This was the case, for instance, for a number of governments in exile during the Second World War. And in that case, this does not fall within the purview of local authorities. And this is also the case for military units stationed on foreign territory and which are run according to the legal rules of their country. But in particular, this holds true for a number of public services, such as educational establishments or museums. But in particular, this holds true for currency. Currency is a public service whose definition and circulation conditions are determined by the issuing state of that currency. And if the issuing state agrees, the currency may circulate outside of its territory. And if, for instance, a currency is devalued, that devaluation is decided by the issuing state. And this will have an impact on the coins and banknotes in circulation and in bank accounts abroad. This is a clear illustration of perfectly accepted extraterritorial jurisdiction. Jurisdiction linked to the state, its organization, and its government are very often connected to the notion of protection of the state or of the protection of national security of the state. And although that kind of jurisdiction is generally accepted, what is difficult is to define its contours. Very often, mention is made of national security to justify this. But of course, the question arises of what happens if you have, for example, a plot or a planned attack against a state on the territory of a different state. Now, in international law, it's accepted that a third state cannot accept on its soil or the soil of a foreign state the preparation of actions against the political organization of another state. The International Court of Justice has had a very close look at this issue in the context of the military and paramilitary activities in and against Nicaragua case, and considered in particular, and here I'm quoting the ICJ, whether there might be indications of a practice illustrative of a belief in a kind of general right for states to intervene directly or indirectly with or without armed force in support of an internal opposition in another state whose cause appeared particularly worthy by reason of the political and moral values with which it was identified. End of quote. However, the court rejected this idea and found, and I quote, that no such general right of intervention in support of an opposition within another state exists in contemporary international law. End of quote. So the court was referring primarily here to armed intervention, but it should also be noted that it referred more broadly to any form of action such as funding or the training of armed personnel or any other kind of political support. So the rule is therefore clear, and there can be no jurisdiction in theory to justify this type of action. So I'll leave that thought with you to mull it over. 30 years down the road after the Nicaragua ruling, and bearing in mind the increasing importance of the fight against terrorism, whose legitimacy and legality require UN Security Council resolutions, the question arises again: is there a different customary rule emerging at the moment? And can we say that states are entitled to act in order to protect themselves from alleged plots against their own security, and therefore to act abroad to protect their own security? And whether this kind of justification can be invoked outside of the circumstances set out by the Security Council. It's a rather delicate question to deal with, and it's not sure that the rule has really changed since the dictum of the International Court of Justice in the Nicaragua case. But it is nonetheless a very topical matter. And more generally speaking, invoking the protection of the state, national security in particular, has sometimes been done in order to justify measures to try and prohibit trading practices abroad by foreign economic operators. There are some well-known emblematic illustrations of this, that of the American Helms-Burton Act against Cuba, for example, in particular, heading 3 of that act, and the D'Amato-Kennedy Act against Iran. These claims were vigorously opposed and challenged by third-party states, and therefore these legal claims were not accepted, and therefore I don't think we can say that there is some kind of new customary rule that has emerged. So after having briefly talked you through the various elements regarding the doctrine of jurisdiction, let us now have a look at the functioning of this doctrine in practice. And in particular, I would like to highlight its adaptability. State jurisdiction rules, as I have already indicated, have an essential function because they allow for the coexistence of different sovereignties, which are in principle on an equal footing. However, this jurisdiction is exercised within the constantly shifting sands of international life, a context that is marked by inequalities of power and which sometimes may give rise to solutions which are based more on power relations than on solid titles of jurisdiction. So we need to assess what is justifiable and what is not. And the first question that arises regarding the functioning of this doctrine is clearly the balancing act between competing jurisdictions. Because, as we have seen, certain jurisdictions can be exercised outside a state's territory. Of course, first and foremost, we're talking about the jurisdiction to prescribe. And public international law in that respect is quite liberal. I'm sure you have all heard about the famous dictum of the Permanent Court of International Justice in the Lotus case, which says, and I quote, "Far from laying down a general prohibition to the effect that states may not extend the application of their laws and the jurisdiction of their courts to persons, property, and acts outside their territory, it leaves them, in this respect, a wide measure of discretion, which is only limited in certain cases by prohibitive rules. As regards other cases, every state remains free to adopt the principles which it regards as best and most suitable." End of quote. So, in other words, no spatial limitation in principle as a consequence of international law, except, of course, when you have specific rules. And today we probably have many more rules than we did back then at the time of the Lotus case. Therefore, in principle, the state is free to determine the scope of application of the laws that it enacts. And in this regard, very interestingly, we should note the presumption of territoriality in the jurisdiction to prescribe, which was asserted by the US Supreme Court in a famous ruling delivered on the 24th of June 2010 in the Morrison versus National Australia Bank case. A ruling within which the US Supreme Court held that there is a long-standing principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply within the territorial jurisdiction of the United States. And when statutes give no clear indication of an extraterritorial application, then it has none. End of quote. So this is a presumption. And of course, the legislators may perfectly well decide to give extraterritorial effect to certain texts. And this is, in fact, what they did occasionally. But it's interesting, and this presumption is based solely on domestic US legislation. It does not correspond to any particular requirement under international law. This position was adopted in this ruling, which sought to overcome a conflict between different potentially applicable laws. And at the time, it was viewed as a return to territorialism. And it stood in sharp contrast to previous positions adopted by the United States, which had focused more on the idea of a balance of interests, where you weigh up the objective, as it were, of each law, why it would be applicable, and the search for a reasonable outcome. These are, of course, private international law approaches, and they are based on a purely national consideration of the matter. From the standpoint of public international law, it's worth noting that the Court of Justice of the European Union has recently declared that the spatial scope of an agreement reached by Morocco and the European Union could not be seen as actually extending to the territory of the Western Sahara, which, as you know, is a former colony of Spain, which is under de facto control by the Moroccan state. And the court ruled as follows on that particular case. It said that to date, the Saharan population had not been able to exercise their right to self-determination, an enforceable erga omnes right, and as a consequence of that, the status of Western Sahara could not be considered as connected to the territory of the Kingdom of Morocco. And the Court of Justice of the European Union, in that particular ruling, relied very heavily on public international law. So, state jurisdiction in cases where there is no determination of the spatial scope of application of a particular law can sometimes clash with the competing jurisdiction of a third-party state. This scenario was actually flagged by the French Constitutional Court in connection with the 1982 French law on nationalizations. The question was, could these nationalizations actually have an extraterritorial effect or scope, given that these nationalized corporations had subsidiaries abroad? The French Constitutional Court said that it is up to the legislator to decide on the nationalization of companies having their registered office in France and, under such, to transfer to the state all of the shares of these companies with all the consequences entailed by these transfers on the administration and disposal of company assets. The limits which may be encountered outside the national territory as regards the effect of these nationalizations would constitute a fact which cannot in any way restrict the exercise of the jurisdiction devolved to the legislature by a French constitution. So, this position is clearly inspired by public international law, and it defines the jurisdiction of the legislator. However, you should also note that it does not preempt a solution to the conflict of law that could subsequently arise, and which may need to be settled abroad in accordance with local rules of conflict. Now, alongside the issue of the link between the various jurisdictions, there's a second question which has arisen in connection with rules of jurisdiction, namely that of the extensive interpretation of classic jurisdiction titles or criteria under international law. There's no shortage of examples to that effect, and they concern all types of jurisdiction. Regarding a jurisdiction ratione loci or territorial jurisdiction, one remarkable extension of that jurisdiction emerged with the application of local competition rules and their application to foreign companies whose agreements or activities have had an impact on the local economy of the local territory. So, for example, an agreement signed by two foreign companies on the territory of a third party state designed to carve up the local market theoretically is not something that should be addressed by local legislation. However, the idea according to which in the field of competition, it's the relevant market that should be borne in mind. And this is where the effects of the agreement are felt. And this solution was initially first recognized by the US case law. After that, it was extended to Europe through the case law of the Court of Justice of the European Economic Communities in 1971 and was subsequently enshrined in 1988 with the famous wood pulp ruling, which stated that the most salient criterion was the place of implementation of the anti-competitive practice or agreement. Now, this case law has spread to many other countries around the world. It is, of course, a judge-made principle and at the outset met with a lot of opposition, but ultimately gained currency around the world as is no longer opposed today. It's an interesting illustration of a new customary law created by national cooperation. Now, of course, limitations have been proposed for the doctrine of effects, and in particular, in 1977, the Institute of International Law stated that in order to be taken into account on the territory of a state, the effects had to be substantial, foreseeable, and intentional. In other words, the foreign agreement had to have made a deliberate attempt to affect the local market. And as regards the question of an extensive interpretation of jurisdiction, if you look at the area of jurisdiction ratione personi, personal jurisdiction, we have already seen the United States extensive interpretation, thanks to the concept of the US person. And this particular argument was rejected by a Netherlands court in a very famous case, the censor case, which was heard on the 17th of September 1982 by a district court in The Hague and concerned the building of a Euro-Siberian gas pipeline at the time, namely at the beginning of the 1980s. The rejection by the Netherlands court to allow this US claim seems to be in sync with the current position. In other words, this American claim doesn't really seem to have persuaded other states or indeed courts in other jurisdictions. And when we're talking of public services and government organization and jurisdiction in that area, there is in fact a very interesting example of extensive interpretation. Since 1979, the United States of America have claimed to have an alleged currency-based title jurisdiction, either on the grounds that the US dollar is being used by foreign operators outside the USA, or alternatively, because of required interbank compensation transactions on the territory of the United States, because the system is such that any US dollar transaction made by banks throughout the world has to be balanced out by an inverse transaction made by banks operating on US soil. So these two arguments, the use of the dollar abroad and compensation of banking assets, don't seem particularly convincing to my mind. Regarding the first argument, the US position was rightly criticized because monetary sovereignty does not imply a right to control the use made of one's currency by a state outside of one's territory, provided that the state has accepted the principle of internationalization. So once you have internationalization, that's it, end of story. Your currency is out there, it is circulating, and the issuing state no longer has any kind of control over that. Of course, it might have control in the form of devaluation, as I've already said, but for the use, it's the local state which has jurisdiction. And in fact, there are states that prohibit or regulate the use of foreign currencies on their territory. And as regards the second point, that is to say, compensation, the US argument is quite debatable because compensation clearly is not a form of monetary transaction. It is merely a private operation that allows banks to settle credit transactions amongst themselves. It's a private commercial transaction, and in no way does it represent a title of jurisdiction recognized under international law. Admittedly, these are legal arguments, and of course, the power of the US dollar is such that in practical life, and notably as regards certain particularly harsh and recent sanctions, these legal arguments have not been considered as particularly conclusive regarding the United States of America, and corporations wanting to operate on US soil in dollars have let themselves be persuaded by the US arguments. Now, sometimes certain states claim new and completely unprecedented titles of jurisdiction. So it's no longer a question of circumscribing or extending titles of jurisdiction, but in fact of claiming titles that were unknown hitherto. These attempts by various states have generally been rather circumstantial and did not last long. You may recall, for example, during the Euro-Siberian gas pipeline case, the US presented claims based on the US origin of products or based on the existence of licensing contracts with US companies in order to try to justify export bans or re-export bans from Europe to the USSR, because at the time it was still the USSR. So, although they might appear justified in the light of developments on the international stage, nevertheless, these attempts to exceed traditional titles of jurisdiction are still liable to generate conflicts of jurisdiction. And in the field of public international law, these disputes can take various forms, either the refusal to accept the claim of the other state, or diplomatic retaliations, or they can trigger a procedure before the court or arbitration bodies. But what is also interesting is that the fact that states are developing measures and actions on the grounds of excessive or abusive interpretations of a title may also be a reflection of a new regulatory need. And this is recognized as perfectly legitimate. There are two most significant examples in recent practice, apart from competition law, which I've already mentioned. There is that of the fight against corruption of foreign agents acting as intermediaries in business transactions. And in both cases, it would appear that the classical definition or understanding of the doctrine of jurisdiction is ill equipped, in fact, to respond to these new cross border regulatory needs. Initially, criticism was leveled against these attempts by partners, but then in a second phase, difficulties were gradually ironed out through multilateral consultations and the signing of agreements by states and state entities and public service bodies. This adaptability of the doctrine of jurisdiction is facing new challenges in today's world. And as young legal experts or lawyers, you will have to find answers to meet these new challenges. And as we don't have much time, let me mention two major challenges. The first regards environmental protection. Amongst the areas of our planet Earth which are deemed to be of crucial importance for the future of our environment is the Amazon. And you may recall that last summer there were devastating fires that tore through the Amazonian rainforest, and there was a loud chorus of international protest. The Amazon was dubbed the lungs of the planet. And just before a G7 meeting, the president of France spoke about an international crisis. Aid was offered by various private individuals. But this international crisis immediately triggered a very vigorous response on the part of the president of Brazil. He recalled that the Amazon is situated on the territory of a sovereign state. Admittedly, the Amazon, in fact, straddles several states, but it was claimed that only this sovereign state, Brazil, has the right to decide on its management and on its conservation. And therefore, the president of Brazil rejected any offers of international help. So that's one example. If you like, of a challenge to question the jurisdiction of the territorial state. And I'd like to mention a second challenge, which is just as crucial and which has to do with digital development and the existence of cyberspace. And having regard to the doctrine of jurisdiction, this is an immense challenge. The digital world has been developing rapidly over the course of the last 3 decades. It is based on the freedom of enterprise because you are creating private companies. And this new world has created a novel space, the use of which is now cross-cutting and offers unlimited access to information. This interferes with the private sphere of individuals and imposes entirely new processes. The recent announcement regarding cryptocurrency Libra to be created by Facebook immediately gave rise to an outcry on the part of states. It was seen as an encroachment on a fundamental aspect of sovereign competence or sovereign jurisdiction. But there's another issue which is also absolutely fundamental, namely the collection and use of personal data, which is an essential element in the tech giants' activities in the digital sphere. And another major problem is, of course, the problem of cyber attacks, which actually impinge on the functioning of our essential public services and our very economies. So, the sheer magnitude of the phenomenon, the power of the private tech giants, and the ingenuity of hackers has made it very risky for states to respond, whose traditional areas of jurisdiction are being directly jeopardized. When freedom of communication through the internet can be seen as real and irreversible progress, but at the same time, it's very difficult to respond when this goes awry. Some states, like China, have tried permanently. Or other states have tried on a temporary basis to prevent access by their populations to information available in cyberspace. And other countries, France or other European countries, have put forward a different idea, namely that of digital sovereignty. Now, that would cover, on the one hand, the capacity to regulate these activities and to guarantee protection of individuals, but also to wield influence on digital economy through, in fact, the application of competition rules. In the USA, digital sovereignty has taken the form of the Cloud Act, which allows the US administration, in fact, to download information stored or transferred abroad by American online service providers. Now, the need to look at certain aspects of regulation has also been seen in Europe in a recent judgment handed down by the Court of Justice of the EU. And we can see that the traditional rules of jurisdiction will need to be adapted in this area. For the time being, claims for extraterritoriality have been put forward in a rather dispersed order, but without any serious opposition on the part of third states. Now, maybe this will give rise to new rules of jurisdiction and maybe a specific regime pertaining to cyberspace. Who knows? But of course, the last and major challenge that we face is the fact that the world's most powerful states are not abiding by rules of jurisdiction, and pressures are being exerted which are in complete defiance of titles of jurisdiction, for instance, and unilateral sanctions or other acts of intimidation are being imposed. It's fair to say that the doctrine of jurisdiction is not a dead letter today, but if ever it were to be forgotten, then the spectre of a Hobbesian universe may well come back to haunt us. Thank you.